I should have said that. Good afternoon, everybody. It's really a pleasure to have as our presenter today Mr. Brian Okamoto, who is with the Orange County Public Defender's Office. He's been with the office for about 17 years now, and he has a wealth of experience from which I think we will benefit greatly from. And the topic that he's going to present on is one area that we deal with every day. So we hope to benefit from his experience. Currently, he is the head of the Orange County Appellate Advocacy and Training Department. But prior to that, he used to represent parents that are charged with misdemeanor and felonies that carry very significant sentences. So he has very good experience in this field, and it's really a pleasure to have him today. Mr. Okamoto, welcome. Okay?
Thank you.
So if you have questions, we'll prefer you use the mic because we have people in Orange County, San Diego, and Lancaster listening. Thank you very much.
Thank you for having me. Can everybody hear me okay?
Yes.
Okay. Well, thank you again for having me. I'm Brian Okamoto. I am a public defender. So I've worked in the Orange County office for about 16 years. I did a year in Santa Clara County. The bulk of my career has been in criminal defense. So a couple years ago, I made the switch over to dependency, and which is, I guess, why I'm here. My criminal background has taken me through different cases, from misdemeanors to the significant or heinous crimes, child molest cases, murders, and you name it. So I was asked to talk about our favorite topic, sex crimes. Everyone's excited, I'm sure. These are the kind of subjects that most people recoil from. But us as parents' counsel, criminal defense attorneys, we have to sometimes run headlong into these cases and jump into the subject matter to a degree that no one really would want to. But that's the burden that we have, and we have to represent our clients with zealous advocacy. So, we're going to talk about the general sex crimes. We're going to talk about how it relates to dependency. But first, I kind of want to orient you a little bit. There's going to be several takeaways from this presentation. I know you guys are having lunch, a little food coma setting in, maybe some fatigue from the court morning, but just a few things I really want to send home. And the first one is the obvious, which is these cases are really difficult to win if you're representing the defendant. So you guys get that because you have these decount cases in your cases, and you are trying to have conversations with your opposing counsel and the judge about what to do, the right thing, how to get them to understand your side of the case, despite the inflammatory nature of these charges. So look, there is a difference between the dependency court case and the criminal case, obviously, right? But one of the biggest differences, I think, is in the dynamic on how these cases are discussed to the trier of fact. Because in dependency, the case comes in at detention. You guys have discussion with your opposing counsel and your trier of fact, your judge, about what this case is about. So there may be an immediate shock value to it. Not really interested. Is that what I said? It's my tie. So you have, oh, thanks, man. I'm kind of fragile. You guys get a chance to have a conversation up front with the parties in the courtroom and your judge, right, at detention. So there's at least a first layer of everyone kind of getting over the shock of these charges. Okay? Then there may be pre-trials where you're having informal discussions with the people. And mind you, you're also talking to people who have seen these cases before, so they're not strangers to it. And then by the time you get to your jurisdiction hearing, you may have had several layers of conversations where you were kind of trying to imprint your version of the events on your trier of fact and your opposing counsel. To whatever extent it works, probably depends on the facts, I get it. But the point is, when that jurisdiction hearing starts, that shock value is not there. Now that's something I think is pretty key when you look at it on the other side, on the criminal side. And I want you all to imagine what it's like. So on the criminal side, you have conversations with your district attorney, of course, right? But if that case is going to trial, that case is being tried in front of a judge and 12 jurors who you've never met before, who've never seen your client, and probably have been avoiding conversations about the subject matter that you're going to be talking about in court for weeks on end. So you now it's ready for your trial. You get sent out to your home courtroom, and you're sitting in the courtroom, and seated next to you is your client. District attorney's a little bit away, bailiff, court reporter, court clerk, and judge, and the room is otherwise empty. It's quiet. You're all waiting for this case to start. There's nerves. The back door opens up, and in comes 100 to 120 strangers. This is your jury. They look relaxed. They've been talking in the hallway with each other. They're filtering in, and they take their seats. And the judge will open up the case with some light banter, kind of put everyone at ease. Hey guys, it's the community. We're here for a criminal case. It's really important. Thank you for being here. And then the judge will read the charges. Now this is a criminal complaint. The jury will not see this, but the jury is going to hear this right off the bat. The defendant in this case is charged in count 1 in violation of Penal Code Section 288A, lewd act upon a child under 14, a felony. In count 2, lewd act upon a child under 14, a felony. In count 3, lewd act upon a child, a felony. And count 4, the same, and then on top of that, the enhancement, the allegation that there's multiple victims. And by the way, this is not the worst of what we see in these complaints. We have cases that are charging like 15, 20 counts of sexual molestation of a child. The jury hears this at the very outset, and you can feel the room change. That relaxed feeling that you got from the jury when you saw them seated, it's gone. And now they're staring at you. They're staring at your client. They've already convicted your client. They think your client is a monster. They think you are the biggest asshole for representing this guy. And they can't believe that you're doing it. And that's how you start your criminal case. There's a difference. So, the takeaway is the obvious. These cases are really difficult once you get started in crim court. And one of the most important things that I know you do too is to make sure that nothing you do in the dependency case is going to lead or further the prosecution of your client on the criminal side. Okay? So, with that ray of sunshine, we'll get into what we're going to talk about. I'm going to go over the common crimes common sex crimes that we find in dependency. I'll let you know now that I'm not going to cover all of them. It is exhaustive. There are a lot of sex crimes in the Penal Code. I'm only going to go over the ones that I think are most common, and with a caveat. I'm in Orange County, so the way Orange County DAs file things might be different the way LA County files things, but I'll still kind of give you an idea of the reason why they do things, at least to the best of my knowledge. There's two types of these sex crimes, those with determinate sentences, meaning that your client knows when he or she is getting out, and indeterminate sentences, which are the life sentences, when your client has a life sentence, like 25 years to life, meaning your client has to spend 25 years in prison before your client is eligible for parole. And if your client doesn't make parole, your client's going to stay in, and that process can continue all the way to a life sentence. Okay? And you can imagine clients who are sentenced under these types of crimes don't get a lot of sympathy from the board. I'm going to touch upon sex offender registration, some of the common terms, probation and parole, and removal. I'll let you know now too that in 2021 the law is going to change, so you can forget about everything I'm going to tell you, because it's going to change. In a way we think is beneficial to our clients. Sexually violent predators, this is a classification of clients who've been sentenced to state prison, and while there they get a psychological evaluation, and if the evaluation comes out that they're a sexually violent predator, they can be confined to a state hospital, and that sentence or commitment can last for life. And then lastly, strategies and dependency. Hopefully there'll be time to go over that, although I'm pretty sure you guys can probably educate me on all that. So let's get into the common sex crimes. And by the way, if you guys have questions, feel free to ask me. Raise your hand. The mic will go around. I do appreciate questions because I know you guys are awake. I appreciate a little interaction, but I don't have the full Penal Code in my head, so I'll do what I can. I'm glad that I've got some friendly faces here, Dennis, and pretty sure you guys can be my lifeline if I need it. You see the deer in headlights look that you're so used to seeing from me? Just intercede. I appreciate it. Okay. This is the most common felony offense that we'll see, and probably for you guys representing parents, this is the one you're going to see. Because, I mean, think about it, you're not going to get the typical sex crimes we'll see on the crim side, like indecent exposure and offenses like that, like misdemeanor offenses. You're going to see something where it's parent on child, typically, right? So the most general crime that would ensnare such conduct would be this. It's 288A. Most commonly filed, it encompasses just about everything. You can see here, oh, by the way, the slides have a lot of detail on them. I don't like doing that normally, so I've kind of violated my own rule. And the reason is because these are also going to be materials for you guys, so you can refer to them in case you're focusing on your lunch or your cases for this afternoon. You'll have the PowerPoint you guys can refer to, all right? But the elements, oh, and the other thing is this. What I've included up here are the elements of the crimes in the CalCrim jury instructions. So these aren't lifted directly from the penal code. When the jury gets the case, the jury goes back and deliberates with a set of instructions on each crime. Think of like a recipe, right? For like a bacon, lettuce, tomato, a BLT sandwich, right? You need bacon, lettuce, and tomato. So for the crime of 288A, these are the ingredients that would go into it. It's a little more reader-friendly for the jury, so they're not bogged down trying to read commas and semicolons and understand the significance of all that. So that's what these are here. You'll find them in the CalCrim instructions. So anyways, 288A1, or A. Touch any part of a child's body, either on the bare skin or through the clothing. So your client does not have to touch a private part, does not have to have skin contact. So it either has to be that kind of touching, or your client has directed the child to touch him or herself or someone else. So there has to be some kind of touching that was instigated by the client. The client has to have the intent, acting with the intent of arousing, appealing to, or gratifying the lust, passions, or sexual desires of himself or herself. It's pretty easy if your client is grabbing private parts to prove this, and that's usually what we'll see. And lastly, that the child was under the age of 14. Second takeaway, remember age. So children who are 14 and up, crimes are going to be in a different classification. 13 and under, 288A, and a bunch of other horrible stuff. 10 and under, really bad. Right, I kind of had this mental image of like wading into the ocean where you're walking in the water, the water's kind of lapping at your legs, and then at some point it drops off a little bit and you're up to your waist. That to me feels like age 13. Then you walk a little bit further and then it dips off and your feet can't even touch the sand anymore. That's like 10 and under. Okay? So there are different levels of crimes based on age. Okay, so just be mindful of age. 13, really bad. 10, even worse. Okay? Now I've probably just messed up your beach experiences. Punishment on this, 3, 6, and 8. So what this is here, this is what we call the triad. So the 3 is low term, 6 is mid-term, and 8 is upper term. So when you get sentenced, your judge has these options. The judge will start at 6 by law. So when I hit sentencing, I'm filing briefs to try to get the judge to go to find mitigating circumstances to get down to 3. Sometimes I'm trying to get probation. On this offense, you can get probation, meaning the sentence will be up to a year in local jail and half time. But if your client violates, you're looking at 3 at 85%. So 85% is mentioned here too because that's significant. Now think about it. If you have a client who's been sentenced to the max of 8 years, think of 8 years at 85% versus 8 years at half, which is what clients normally get in state prison. So that 85% number is significant. What it also signifies is that your client has been convicted of a strike offense. Strike offenses are in 2 categories. There's violent felonies and serious felonies. They're both strike offenses, by the way. But the violent felonies carry with it you earn credits of 15% and not half time. So significant when you have great sentences like this. Just something to keep in mind. I can get probation on a case like this, maybe, but I have to submit a psychological evaluation. We call them 288.1 reports. We'll get a doctor, kind of look the client over. We'll get a good report, give that to the district attorney, and try to negotiate probation somehow. But usually we'll get an indication that it's possible. The DA says probably not, or we get the feeling that it's not. We're not going to waste our time or put our client at risk by giving the district attorney a report that might have some information that could be possibly even used against them. So we do have to be a little bit vulnerable when we do it. I can talk about that a little bit later too. All right? Yes?
Would there ever be anything helpful in the dependency proceedings contained in that report that could help us in our cases?
You mean in the social studies?
Anything in the 288.1
Oh,
report
you
that
mean
you're
that would
doing?
help independency? Yes. So you guys, everyone hear the question? Whether or not the 288.1 report in the CRIM site can help the dependency case? The answer is yes, I think so. Anything you can use that shows your client is not a great risk, right? Because what's the concern with child molesters? That they are incurable and they're going to do it again, right? Everyone has at least this fear in the back of their mind that that client is potentially the guy that as soon as he gets out, he's heading straight to the park. And you're going to snatch some kid off the slide, right? And then do this and that. And that's everyone's paranoia, right? That, you know, as soon as you let the guy out, he's going to go right back to it. He has no restraint whatsoever. So if you have a report, a 288.1 report that shows by some type of objective measures that your client is not a risk, or at least a great risk, or low risk, then certainly that might be something that can help shape opinion in your courtroom. But here's the thing. You guys know your parties. You guys know who you're dealing with. You know whether or not you can change someone's opinion in that courtroom. I know I deal with some people in dependency who I sometimes feel like evidence isn't always so accepted, to put it lightly. So, you know, it's one of those things. It's a judgment call, and it really depends on your parties. Okay. Yeah.
So our client gets popped, and a year later we see the dependency petition, and the trial has occurred and he's been sentenced. How do I get the 288.1 report? Where do I find it? Who do I talk to?
Well, you'd have to find out who, everyone get the question? How do you get the 288.1 report, assuming the client has already been tried and convicted? So you would have to find out from the public record who the defense attorney was, and then contact that defense attorney directly. That's probably the easiest way to get it. The record, and by the way, that 288.1 report may not be in the public, it's probably not going to be in the public record. We don't always give those to the judges. It's usually a negotiation tool with the district attorney. It could have been used in the sentencing, and if it was, then it could be in the record, but you know, under seal probably. So there may be some barriers to getting it by way of the court and public process, but because you represent the same client, the defense attorney should gladly hand it over to you to assist the client. All right? Yes.
We have a lot of clients that where the allegations are found to be true, and they will engage in programs and actually comply with the case plan, but there will be still that concern that they still pose a risk, that they're going to snatch the kid off the slide. I feel like those 288.1 reports might help us at review hearings. Is there a way that you would recommend that we seek those out for obtaining, to try to persuade the judge that the risk is lessened?
Yeah, and that's a good question, because these 288.1 reports could be useful not just at juris or dispo, they could be useful at the review hearings when you're asking for a return, right? Or whether or not there's a likelihood of return, right? Services are working and so forth. I would suggest staying in contact with the criminal defense attorney on that, right?
No, but my question is, even on cases where there isn't a criminal case,
Oh, I see. Okay.
how would we individually seek those out if we wanted to get a 288.1 like report for our clients?
Well, there are experts that specialize in this. So we have a list of experts that we go to for the CRIM side. We obviously use that list on the dependency side too. So the experts, you know, you're looking for any kind of doctor who's aware of several tests. So I'll segue for a little bit because there seems to be some interest in this topic. The doctor should use one of several tests. One of them is called the ABLE test. I think it's ABEL. This is a test that's probably it's probably the easiest for your client to go through. This is the one where the expert will show up, sit in front of your client with basically like a photo book. There'll be pictures of kids or adults, and the doctor is evaluating how long your client is spending on each photo. right, and timing it, and seeing where your client's interests kind of stack up. It's a test that we've subjected our clients to on numerous occasions. It's led to some pretty good reports. I'll tell you that when it comes to settlement, it's a useful tool. To put that on the witness stand, it's subject to, you're vulnerable, I think. And there's concerns the test is not as comprehensive or reliable. But that's one possible test. The other test is, there's static tests like the Srazzo or the Static 99. And what these do, they're formulas. You plug in information that's static, like the age of the defendant, the victims, whether or not they're in the household or know each other, whether or not there's prior convictions for the same, and so forth. So it's a formula, and it'll spit out a number to kind of indicate risk. So that's one. That's probably the safest one, okay, because that doesn't really require much of your client. The expert will also sit down with your client and do an evaluation, probably on multiple occasions. So factor in about 10 hours for your expert to go and sit down with the client and analyze the whole case. And then lastly, I shouldn't say lastly, there's others. I'll get you. There's others. The other one is what's called the MMPI-2, and that is a personality test. That is probably the most comprehensive one. There's different sections in the MMPI. There's one that even encompasses sexual assault. So that component of the test can be used. My office does have some concerns about that test because it's the way the questions are posed to the client. Your client could register could give some answers that could kind of lend itself to an interpretation your client may have hints of being a sociopath. So a good expert can explain it in a way to say, like, no, look, that's not what this means. Okay, but the problem is, once the jury hears even a mention of that, it's so hard to pull back and get the jury reoriented on what the science is. So we do have concerns about the MMPI too, but here's the thing. If you're doing this test privately and on your own, then it's yours, right? And yours only. If that test doesn't come out the way you like it, then you have no obligation to turn it over. And I think you have an obligation to your client not to turn it over. And you bury that report. Okay? It's just one way of measuring it. If it is good, you've got a pretty good diagnostic evaluation of your client that's credible, that you can turn over to using your dependency case and the criminal case. And you've got a slew of experts that we could recommend.
Yeah, our office has used Amy Phoenix twice. Ken has approved. Yeah, our office has used Dr. Amy Phoenix twice. Both petitions were dismissed based on her testimony. And Ken has approved her as an expert, and she's well recognized within LA County as an expert. The only problem, she lives in Morrow Bay, so she has to come down and interview. So a lot of times what we'll do is once she's given us the thumbs up, we get the other parties to stipulate to allow her to testify telephonically. And so far, we haven't had a problem. So in both cases in the last 4 or 5 years that we've used her, both petitions were dismissed based on her analysis. She's never been challenged. There's been no voir dire, no questions, and the petitions have been dismissed. I'm not sure if she's on the new list that Ladle is putting together for the experts, but we have the information on her. And she uses the myriad of tests, and for dependency purposes, it works. There's no jury, and she impresses, and she's really good, so she impresses the judges.
And that is really important, is how your expert is going to testify, right? Because there are some experts who write wonderful reports, and on the witness stand are just atrocious. So you've got to be careful that if you anticipate the case is going to go to litigation, then you're going to want someone like Amy Phoenix. It sounds like she's pretty reliable. Okay? And I can talk to you guys more about evaluations too later. All right. So anyways, 288A, most common. Second you might see is 288B. This is the same thing as A, but add force to the equation. When you add force to the equation, the penalty goes up. So you see at the bottom it's 5, 8, and 10. No probation, 85%. The sentences can run consecutively on this one if it's the same victim on different occasions. Now, that's open to interpretation. I spoke with an attorney in my office just this morning, and she feels that we've got arguments for the judge to run these concurrently, or at least 1/3 of the midterm. Something to keep in mind about force is that the way it's stated, it makes it seem like it's this extra burden that the district attorney has to prove. But I want you guys to be mindful of this. It says force, violence, duress, menace, or fear. So what exactly does that mean? And I'll tell you, the explanation's on the next page. Don't read it right now, all right, because there's a lot. But you know, think about this. The force has to be greater than that necessary to accomplish the act. So if the act is touching, it's greater than the hand moving toward, you know, whatever, okay? But think of it. The adult is a bigger person, a heavier person, right? Is more imposing, is an authority figure. So already you're starting to have elements of force. Now you might be telling yourself, there's no way that's enough, right? But you know, add to it. What if the child is resisting just a little bit, right? What if, like if you look at duress, you know, the parent in a role of authority controls the child to a certain extent, you know, and withholding things from the child, is that going to be enough? So you may think, well, maybe it's not enough, but from the jury's perspective, who already doesn't like the allegations or your client, if the jury finds your client guilty of the underlying offense of 288A, will it be that much of a stretch for the DA to get a B count? So I'll leave that up to you and your juries. You guys are in LA, not Orange County. Maybe you guys will have better luck. But it's just something to be mindful of. It is an extra burden for the DA, but you know, in practically speaking, you know, I don't know. The jury might feel differently depending on you know, how things work out. Like, look, honestly, I always feel this about these cases. I gave you the scenario about how these cases start in Supreme Court, right? With the jury looking at me and my client that way. And you guys know what the law is. The law is that the burden is the district attorney's, right? And the burden of proof is proof beyond a reasonable doubt. And my client is innocent unless proven guilty. These are all common understandings, right? But when those charges are read, everything seems to feel like it's flipped. It now starts to feel like it's my burden to prove innocence. If this kid is lying, why? Prove it. Prove it to me. Everything shifts. So you do what you can to kind of shift the balance in that courtroom through jury selection. But sometimes, depending on, you know, how things go, it can feel like an uphill battle. So the point of all this is that don't underestimate the elements of these offenses, okay? Because if your case lacks a lot of jury appeal, and a lot of these cases do, it may not be that hard for the DA to reach a little bit further and get some of these allegations. If the victim is 14 or 15, this is 288C. Remember, age matters. 14 and 15, this is a better sentence. I wrote wobbler, which means it could be a misdemeanor or a felony. The prison sentence, not even prison, it's 1, 2, and 3, and it's half-time on this one. So just remember the age, 14, 15. Defendant, 10 years older than the victim. Okay? But same species of crimes, this is all in 288. Stat rape, you guys know what this is. Unlawful sexual intercourse, underage person. I haven't had one of these in years, by the way. It's probably 10, 12 years or so. I haven't seen one of these. So when I look back at the instruction, I noticed that the people still have to prove beyond a reasonable doubt that the defendant did not reasonably and actually believe that the other person was at least 18 years old. So that is the defense still. Punishment, if the child is within 3 years of age, misdemeanor, more than 3, wobbler, over 21, minor under 16, wobbler, 2, 3, and 4. By the way, 1170H here, what that means is that your client's going to serve that prison commitment in the county jail. All right? Everybody okay with these as I'm just flipping through? All right. All right. This is just mainly for awareness and reference. Continuous sexual abuse. Think of 288s that happen on a prolonged basis. So 3 months, basically, is what it is, and 3 or more acts. The reason why you should be mindful of this is the punishment. The punishment kicks up to 6, 12, and 16. And at 85%, that's pretty significant. So the DA in Orange County doesn't really file this very often. And I think the reason why is because if there are multiple acts of 288, the district attorney probably would rather just file individual counts of 288 and stack them up. Because when you stack up all the offenses, the punishment's probably going to exceed 16 years. Okay? Also, think of the effect on the jury. When the judge reads these charges at the beginning and it's just one count of 288.5, bad, right? Of course. But what if there's like 10 counts of 288? Just over and over and over again, the judge reading those charges. It's like death by 1,000 cuts. It's horrible. So there is some impact there, but on occasion they will file it. Just be mindful that this code section is there. Other common crimes: sodomy, oral copulation, sexual penetration. When you think of penetration, it is usually for an object or digitally, fingers, okay? And sexual battery is just your general, think of battery, but with a sexual intent. So battery is an unlawful touching, very general. When it comes to penetration, sodomy and sodomy and penetration, the law says that the slightest penetration is enough. So it is not a defense. You cannot argue to a jury that it didn't go all the way in. All right, it's an uncomfortable defense. I've had to run them. But you'll see in some of the evidence, if you get the discovery, there's usually a video of the child being interviewed by the social worker. And at some point, at least in Orange County, a tissue box comes out. You know that part of the tissue box where the tissues come out? Okay. Well, they'll hand this box to the kid. They'll ask the kid how the kid was touched in the vaginal area. The kid will demonstrate if there is even just the slightest penetration between that opening, then you're looking at penetration, okay? So just be mindful that there are no degrees for depth on this one, okay? These are just the other crimes that you're going to see. What we've noticed is that the district attorney doesn't file sodomy, oral copulation, sexual penetration. It's usually a 288A. Now, on occasion, they'll file the sodomy and penetration charges if there's force, just to kind of increase the penalty. I don't know exactly why the DA does it. I think the DA may be thinking that 288A, just with its broad language, is easier to prove. It's simpler. Okay? They don't have to go into all these details. If the kid gets a little squirrely on the stand, as long as there's some kind of touching, they've got a conviction. Okay? And if you look at the enhancements and the ways to get to life, you'll see why they don't really need to file some of these charges. Okay? In fact, we've even heard from DAs that they don't even file everything that they could in the police report. Because remember, at the end of the case, the jury has to go back and kind of dissect all the facts, go over the law. And if it's all confusing with different crimes and elements, it can take a little bit longer. It can be a frustrating process when you really don't have to do that. If you guys have seen the penalties here, it's enough. Look at the next section. So, always should be a concern when you are thinking of age. Okay. Remember I mentioned age 10, so age 10 and younger. So if you have a child 10 and younger and sexual intercourse or sodomy is in your case, your client is looking at 25 years to life. This is all that needs to be alleged. Just one count and it's life. Okay? There's a parallel provision to this under B. This is for oral copulation and penetration. Again, child 10 years of age or younger, defendant's at least 18 years old. This is 15 to life. Every incident of this that's happened will get stacked on and it can be a consecutive sentence. So these are the charges to really be concerned with. I put this up as just an example. I'm sure it's possible to read from where you're at. You guys on the screen, there's no way in hell you can see this. But this is what a sentencing can look like. It can be really convoluted. So I had this trial where my client was charged with 11 counts, of 10 of which were 288A, and then one 288.7. You'll see down here the enhancement under 667A. Those are two what we call nickel priors. These are 5-year non-strikeable priors, at least back then. And then my client had 2 strike priors. So in this case, just to kind of orient you on the wonderful time that I had in this, my client was in Colorado, got married, had a child, molested the child, convicted. Got released, married someone else, had another child, molested that child, convicted. Came to California with 2 prior convictions for basically what were 288As. In Orange County, gets married again, has another child, same thing. So, I got 2 strike priors. I have evidence that's admissible against me from the priors. And I have what's called a cold call. You guys know what those are? Okay, a cold call. So what happens is that the police will sit down with the victim child. They will have the child call your client. The police will be listening in. The child will be the only one speaking on the phone, and the child will ask questions to your client like, why did you do this to me? How could you ever do such a thing to me? Why did you have sex with me at the age of 8? Why did you put your penis in me? I mean, very explicit questions. And in this particular phone call, my client's responses were, I'm sorry. I hope you can forgive me. I love you. I know you can't understand that. In the middle of the call, he stopped and said, they're coming for me, aren't they? Told her again, he loved her, hopes he can forgive her and apologize for everything. So that was the starting point of my case. So, and it went to trial. So you guys are wondering how I can possibly stand up in front of a jury without a paper bag over my head and argue this thing. I did. And the defense in this case, because look, you have to concede some things. So I did concede a lot of the charges. The defense on it was age. So what I was really attacking was this up here, the 288.7, and trying to get the child to be over the age of 10. If I could beat the life count, then the second part of the attack was to live with my 288As, because remember, those are determinate sentences. Those are not life sentences. And then to go after the strike priors. So if I get the strike priors dismissed, then I can avoid life. And then I'm just looking at multiple 288A sentences. So my client wouldn't be looking at life, but probably in the ballpark of, I don't know, 30 years. That's a win. Yes. All right. It was a difficult case, of course. You prep, you listen to the evidence for months, up to a year. I spent probably a year and a half working up this case. I knew every detail of that recording. I had an angle for every single statement, something. You have to, right? You're responsible for defending this person. I got to the point where I can listen to that recording and just kind of step back and just try to analyze it and break it apart. And then it got played to the jury. And it felt like it was an hour. It was just silence and that voice, those voices. And then interrupted only by the turning of pages of the jury as they're going through the transcript. Up until that point, the jury was listening to me. They listened to cross-examination. They had notepads. They were taking notes. It's like watching tennis. The jury's looking at the witness, then at me, then the witness. They're engaged. As soon as that recording was done, those notepads went under their chairs. They all kind of sat back in their chairs, back, and just watched. But it's devastating. So on that case, the exposure, understandably given the conduct, was, well, maybe not even understandably, was 335 years to life. So what ultimately happened was conviction. When we got to sentencing, the district attorney wasn't ready to proceed on the strike priors. Those got dismissed. And my client got, I think, 47 years, something like that, to life. Still a life sentence. My client's 50 years old, so it's basically LWOP. But I put this up here so you guys can see the complexities of sentencing. So you see in the first category, this is the range without strike priors, 47 years, okay? The second one is if you impose one strike prior, because a judge can actually strike priors for sentencing. So the sentence can get a little lighter. So if the judge struck one strike, my client would get 94 years. But if both strike priors get imposed, it's 335 years to life. So sentencing can get really high, as you can see, all right, understandably. But you know, there is the argument of cruel and unusual punishment. We do raise those. I did raise that here because at some point it's ridiculous. Really, is my client ever going to serve 335 years to life? Of course not. So it's ridiculous. Question back there. Question?
I was actually going to ask about the 335 years. What does that actually mean? What does it play out to in practical terms?
It basically LWOP. Your client's going to die in prison. It's a ridiculous number, right? It's just there is no purpose to it. So it's what your client would get. So I mean, look, honestly, my judge is probably motivated to strike those strikes because it's all academic. There's no purpose. Okay, I got a lot to cover, but you guys have been great. I'm going to zip through this, okay? Other life charges, bodily harm, we don't really see this one. Sexual assault of a child, less so, but we do see this, so keep in mind, a child under 14, 7 more years younger, has to be one of these crimes, life, 15 to life. These are one-strike offenses. I'm going to zip through these because I want to get to other things, but take some time to look at it. This is a formula, just real quickly. So you have to be charged with a C offense. While you're being charged with a C offense, If your client has a circumstance in subdivision D, which is one of these, 25 to life. If your client is facing a C offense and has a circumstance in subdivision E, it's 15 to life. If there are 2 or more circumstances under E, it's 25 to life. The one I want you to be mindful of is this one is multiple victims. This will be present in your cases if you have a parent, a dad, who's molested 2 kids in the family. Because there's 2 children, that's multiple victims, that's 15 years to life for each child. That's 30 years to life. You may have an argument that to impose 30 years is cruel and unusual punishment. A case just came down a couple weeks ago, finding that the sentence was cruel and unusual punishment. I applaud you, LA, because it was your DCA that did it. My DCA didn't do it. We reversed the judge, shamed the judge. He got booted out of cram court for doing something like this. Your DCA went along with the argument, found it was cruel and unusual punishment. It's the direction things should go, seriously. Okay? It's ridiculous. In that case, it was touching over the clothing, it was 2 victims, it's bad, I get it, it's a crime, it shouldn't be punished, I get it. 30 to life, okay? Absurd. So, your DCA did the right thing on that, I think. Okay? So, be mindful of that. 290 registration. There are qualifying offenses here. Don't read this now. Just know that it's there. Okay? 288, of course, is in there. There's some misdemeanors, but just think anything that involves molestation against a child is going to be in there. Just assume that. Okay? If there's a crime that is not in 290, but it has elements of sexual misconduct, the judge has discretion to impose 290 terms under this code section here. I asked around my office to see if anyone's had that. The only thing I heard about was like upskirt pics, but this is pretty rarely used. Question?
Yeah. Sometimes we get counts that are like so-and-so is on the 290 offenders list, and mom failed to protect the child because she let so-and-so around the child. Is there anything that we should be attempting to discover in terms of, is there like some reports or something that we could get to demonstrate that this person, yes, is on the list, on the offenders list, but has been in compliance with whatever requirements there are, type of stuff?
You mean on the registrant?
Yeah.
Yeah, so, and I'll talk about that, well, let's talk about it now, Megan's List, so you may have heard of that. You guys can go onto the internet, look up Megan's Law, and then if you really want to scare yourselves to death, look at where you live, and you'll see a lot of dots, of each dot representing a sex registrant. And if you click on them, you'll see what the offenses are, you know, things like that. So there's public record to see who these people are. That's one. To get specific information on whether or not the person's been in compliance, that I don't know, if it's not your client. So if it is your client, I would assume you'd be contacting the probation officer to find, or parole officer to see how your client's been complying with the terms and conditions of registration. I'm not sure if that answers your question. Obliquely?
No, it did. So, like, who should we actually reach out to if it is my client?
Probation or parole.
And, okay.
Yeah, they'll be able to tell you if your client's in compliance. Yep.
If you ask your client, if your client, when you do the initial interview, ask your client, many of the client themselves will have the conditions of probation and parole. So you can just review it. They'll have the actual, it goes check, 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 it has the various check boxes. Because as you know, we get a lot of the registered sex offender petitions dismissed because depending on their status, they are not the guys who have to sleep under the bridge. They're actually the folks that can have their own children. Many of them have already completed classes in order to get out of prison or as a condition of their probation and parole. And as long as we get that information, you know, we're pretty good at getting those allegations dismissed.
Yeah. Yes.
Jason, that was actually one time I used the ABLE exam that he mentioned earlier, and the, what is it, the
MMPI?
Yeah, because they have to like do a process to get off the registry if they want to, if they're compliant with their terms of probation. So.
Right, and so she just touched upon getting off of registration, and I'll talk about that in a second. just real quickly, registration is lifetime for now, okay? Until 2021, then there's going to be a tiered system, all right? But for now, it's for life. You have to register annually, so every year after your birthday, you've got to go to the local law enforcement agency and give your location. If you're transient, you've got to do that every 30 days. I mean, come on, think about your transient clients. Really? They're going to have little alerts on their smartphones telling them to go and register every 30 days. Or 5 days for the moving. There are residence restrictions, which I know you kind of brought up. So some require you to be no closer than 2,000 feet from a school or a place where children typically gather. There are constitutional arguments on that. I know in Orange County, where there's a lot of parks and schools, it was basically impossible for anyone who's a registrant to live in these communities. The court found as applied that was unconstitutional. Okay, so take a look at, you got to do a map and see whether or not it's even feasible to live anywhere outside that 2,000-foot range. This was interesting too, that if you're a registrant, you cannot go to a school without lawful business and written permission, and if you do, it's a misdemeanor offense. Okay? And the interesting thing was, if you want to volunteer as a registrant, then the school will notify, they can notify every parent of each child at the school that you're coming. So that would probably take away your charitable feeling of volunteer. And you know, don't forget that for some of these registrants, the information is public. The Megan's Law website, take a look at that and be scared. But you'll see there's some information in there. You can ask to have the information removed from public view, and that's under that code section. For probationers, meaning you serve local time and you got out, you got to do a sex offender management program, not less than a year. You have to waive your privilege against self-incrimination and waive the psychotherapist patient privilege. I had a client who was calling me up after I got him misdemeanor offenses. He was struggling with this because he didn't want to admit everything in his program. So he resisted. No violation ever came to us. So I'm not telling you to tell your clients not to obey, but I don't think it's worth it personally. I don't think they should have to admit every single thing they've been accused of. So my client was charged with oral copulation of a child under 10 and under. When the case was done, he had misdemeanors for annoying a child. That was it. And the doctor was trying to get him to admit that he did the oral copulation, which he refused to do. No violation came of it, nor should there be after what he pleaded guilty to. But it is there. We don't see the at least I haven't seen the violations from that side, but just know that that provision is in there under that section. For parole, there's a residency restriction. This might be more applicable to you guys. When the offense is against a minor, you can't reside, work, or volunteer at a child daycare facility. No brainer. There's the code section for you. Violating that is a misdemeanor. There's again the intensive parole supervision that you saw for probation. There's also the GPS requirement. So if your client goes to prison, comes out, you slap a GPS device on your client. Failure to register, it's a misdemeanor if you have a misdemeanor offense that you're registering for. It's a felony if there's been a previous failure to register on a felony registrable offense. Punishment is 16(2) and 3. But be mindful of this, that if your client is convicted of 288A and 2 counts of that, that's 2 convictions, okay? Let's say there's 2 separate cases. Your client has 2 strike priors. And these are kind of what we call super strikes. These strike priors mean that if your client picks up a new felony, any felony, doesn't have to be a strike felony, any felony, it's 25 to life. So if your client fails to register and has these conditions, and they charge that as a felony, your client could be sentenced to 25 years to life in prison for failing to register. Okay. Now, practically speaking, even if it's charged, we don't see clients getting 25 to life on that. In fact, we don't really see it charged. It's there, just be mindful of it. Okay. And for transients, there's the punishment. You guys can look at it later. Removal. This is under 290.5. This is going to change. So, for now, you can do what's called an expungement, which basically, you know, is like a plea withdrawal in a sense. It expunges your record, but unfortunately, it doesn't relieve you of your duty to register. Okay. You instead have to do a certificate of rehabilitation, which doesn't always relieve you of your duty to register. And practically speaking, if you have a 290 offense and trying to get that certificate of rehabilitation, tough to get. Okay, that's also tough to get. The most guaranteed way of getting it, you're relieved of that duty to register is a governor pardon. Good luck. That's not good. But it's there. It's kind of like one of those illusory rights. So there it is. Expungement, certificate of rehabilitation. Oh, and just to be clear, the certificate of rehabilitation doesn't apply to a class of crimes. 288 is included in that. And there's exoneration, the other way to get it done. So look, the takeaway from this, it's pretty difficult to get out from underneath the registration requirement. Okay, it's really difficult. In fact, I don't even try to even sell my client on the hope of it. I'll explain the process, but it's not something I'm real confident is going to happen at all. Now the law is going to change for 290 registrants. So look for this. In 2021, instead of every single registrable offense being a lifetime registrable offense, there's going to be 3 tiers. Tier 1, you can petition to be relieved from your duty to register after 10 years. Think of misdemeanor crimes, non-strike felonies. Okay? Tier 2, after 20 years you can petition. That's a different class of crimes. And I've listed some there. Take a look at the list in the code section. And then there's the lifetime offenses. You can imagine the worst of the worst. Okay? These are the most heinous crimes. Murder with like sexual intent or something obviously is in there. And so forth. So there will be 3 classifications coming in 2021. Now the process is this, is that the time period, that 10-year period is going to run from when you're released from custody. On your birthday, or after your birthday, after that 10-year, 20-year time has expired, you can petition to have, for that relief. I think the criteria is basically you have to be out of custody, off probation, parole, something like that, and no intervening crimes or so forth. So that's to kind of get you in the door. The district attorney can object on grounds that you pose a risk to public safety. So I would imagine at the beginning there's probably going to be that fight because everyone tries to figure out what exactly that means. Question?
Yeah, and how far, I mean, so in 2021, so it will be for all sentences as of 2021 going forward, or can clients who have prior, let's say they've gone 20 years without another offense, can they grandfather in?
That is a $1 million question, and that is going to be, I mean, you can imagine, that's going to be heavily litigated. You kind of see the arguments, like, you can see the people taking their positions on that. But that is definitely going to be something that's going to be fought. So I think that is fight number 1. Number 2 is going to be what exactly does it mean, that risk of public safety, to public safety. I could be wrong. This could all be cleared up by the time we get there. Just looking into a crystal ball, I can see that being a problem. Okay. And I don't know if the code section does clearly state if it contemplates, you know, going forward, but we'll see. We'll see. Sexually violent predators, you guys don't need to know exactly what this is, just know it exists. So that at the end of your client's prison sentence, your client could be visited by a doctor who works for the state prison, who's going to evaluate your client and determine if you are a sexually violent predator. And if your client is then going to be transferred to a state hospital, potentially for life. So even if your client is done with that long sentence off of those sexual offense charges, your client doesn't go home, your client could be in a hospital. So be mindful that that's there. There are triggering offenses. I don't want to go into detail about that. That's a different lecture. Okay, so dependency. Let's see. How much time do we have? What time do we finish, guys? 5 minutes. 5 minutes? Sure, we can get it done in 5 minutes. The question that's on your mind, I'm sure, and it's on our mind, well, we have a decount case. Okay, we want to know if the DA is going to file criminal charges, right? We have no way of knowing this. There's no crystal ball. The DA is not telling us and tipping us off in advance, right? So we're just kind of guessing. But I can tell you, in looking at the cases from the crim side and the dependency side, here's what I see. On the criminal side, the charges are filed when there is something that corroborates, okay? Meaning, it's not just what the kid said. There's a cold call, there's your client's confession, there are other witnesses, there's other children who are victims. There's something more, or physical evidence. There's something more than just what the child said. Now, don't get me wrong. There are times when the district attorney will file on just what the kid says because it just comes across credibly. Okay? It's not a straight, it's not a hard and fast rule. Okay? corroboration. So what I've noticed is that dependency is kind of like where the 288 cases go that don't have corroboration. You know, where they're not that strong, the DA doesn't have a lot of confidence in, they show up in dependency. Those seem to be our D count cases. But still, you know, it still worries me. Like, I'm still paranoid. I still think about the risks my client faces on the criminal side. If we do anything on the dependency side that's going to tip the DA off. I don't know what is keeping DA back from filing. Okay? If they're looking for corroboration, I don't want to do anything in my jurisdiction hearing that's going to give the district attorney corroboration. If the district attorney has concerns about the credibility of the child witness, remember, I mean, that's probably like our go-to defense on these charges, right? The kid's lying. If that kid gets up in your jurisdiction hearing and testifies credibly, is somebody going to tip the DA off? Do you guys have suspicions that your social workers are talking to district attorneys?
We have some suspicion. People versus Leo.
You know they're talking. Yes. So you know that there is, you know, some cooperation there, right? In fact, you know, there's information here that shows that they do kind of communicate. And I do know that they talk. Because when I was on the crim side, I would get through discovery some documents that come from the 827 file. So I know that they're working together. And of course they are, right? So will the social worker who's watching my jurisdiction hearing call the DA and say, hey, you know that kid you're worried about was perfect on the witness stand. Okay? Took the cross-examination and just batted away everything that defense attorney did. I don't think you're going to have a problem. Will that be enough to convince the DA? I don't know. You want to take the risk? When you're looking at life, 25 to life, 335 years to life, these are things that you kind of have to weigh. I know you guys know this. Okay? Sometimes the district attorney is even waiting for evidence from the dependency case. I've heard this too. So they want to see how things shake out. So again, do you really want to push jurists when this could be happening? Okay? Yes?
Could it hurt their criminal case at all? Because like, I just had a case where my judge dismissed one child completely, and he dismissed the D against the kid because the guy was sleeping with his niece by marriage, who was 16. But can it, but like my judge had stated, he's like, I think this happened, I just don't think these kids are at risk. Does that go to
God, you have a great judge, first of all. And real quickly on that, yes, it can help the criminal case. So we had one where the parents were in a custody battle. And so the motive to lie was crystal clear. We were very confident the district attorney would never file that case in a million years. We pushed the jurist, and of course we got the charge dismissed. In fact, there was a C count put on the mom for coaching the kid to make these claims.
What she's describing is a very successful. What she's describing is a very successful defense that we run all the time, which is basically Rubicella. And our judges do follow Rubicella, and it's not dead. However, what Dennis said about the Theo case that just came down, 3 weeks ago, is a huge reminder that regardless of what defense we are running, which might be successful in the dependency court, anything our client says to a DI or a social worker, that social worker now is available to testify in the criminal case.
Right.
So it's a huge wake-up call for us to make sure when there are any pending charges that our client should not be interviewed, because that social worker can be called. The question I have is that if there's a DA reject, so what we're hearing from our client is, you know, I was in jail for a day or two and then they let me out, okay, which is very common in DA reject. So then our case goes forward, let's say the social worker interviews our client because it's a DA reject. Are there cases where the DA will then refile?
Yeah. Yes, absolutely.
So,
They can file.
so even if it's a DA reject, the attorney should be on notice that they shouldn't be interviewing, period.
Absolutely. Yeah. DA reject doesn't mean you're safe. Statute of limitations on a lot of these offenses is when it's up to age 40. The child's age 40. So, but you know, obviously once the crime has been reported, it's a different rubric, but still be mindful that there's still people watching these cases. So I'll get to my last point, which is invoking. I don't know how you guys invoke here, but we're allowed to invoke globally or specifically. We can invoke as to just the incident itself, and have the client discuss services and visitation. We can invoke on social history. I sometimes, if the case is where I'm looking at life, I don't want them talking to my client at all, because I don't even want to take the risk that my client's going to slip up and say something else. Okay? People versus Geo is there. Thank you, Dennis, for tipping me off to that earlier. But yeah, careful. The problem with that one is that your clients are being talked to by the social workers before you're even involved. So it's tough. Yeah.
A couple of issues that come up. Most importantly, our burden of proof is really low. Most of these get sustained. If our client's given services, it's usually that they have to do a sexual abuse perpetrators program.
Yeah.
And if they don't admit that they did anything in the sexual abuse perpetrators program or counseling, they're never going to get their kid back. If they admit and it then becomes part of our court file, are we looking at issues? Is that?
Yes.
I mean, do they stay in it typically, or have you had experiences where, you know, the DA or the investigating officers have stayed in touch, you know, maybe 6-12 months down the line on a case?
I have not seen it actually come to fruition, but it is absolutely something of concern, right? Of paramount concern. So yes, it's true that things that your client says in the case plan services are supposed to be privileged, right? But what does that mean? Does that mean the DA is never going to hear about it? I don't trust that. I mean, like, the concern is not necessarily that that statement's going to be used against me. Of course, that's one. But it's also whether or not that's going to tip the DA off to the validity of those charges. I don't want to make the DA feel encouraged to file anything.
I have a microphone.
Oh, sorry.
Brian, we're at time.
When we have a client come in detention and we recommend that they go on and get enrolled in classes right away to help us out at the jurist phase, does that admit some sort of culpability in criminal court if they're already enrolled?
Not necessarily, as long as you instruct your client not to discuss the specific allegations. So your client can participate in services and kind of go along with it. The client can still work on issues like boundaries, education, right, understanding the child, those kinds of things, but just not, the problem is this, you really have to trust your client, right? You have to have a client who you know is going to follow what you're telling your client to do. So many will get into those sessions and just start spilling the beans, so you got to be careful.
So we're at time, guys, but Brian can stick around and answer any questions for people that don't have to go back to court.